Hello, I am Judge David Hamilton, the Administrative and Presiding Judge of the Akron Municipal Court. I am one of 6 judges on the bench. Our courthouse is located in downtown Akron, which is in Summit County, Ohio. All 6 of us care about the public and want to make sure all court users can easily access resources. Journalist Sara Shookman is joining us next, and Sara will be describing the services available to self-represented litigants involved in an eviction hearing.
Hello, I'm Sara Shookman, and today we'll be discussing what happens when you're being evicted and the resources available to pro se or self-represented litigants. Eviction hearings. In order to remove a tenant from a rental property, a landlord must file a forcible entry and detainer action with the Akron Municipal Courts. In the first part of a forcible entry and detainer action, or an eviction, a magistrate determines who is entitled to possession of the property, either the landlord or tenant, and whether a writ of restitution should be issued by the court. In the other part of a forcible entry and detainer action, called the second cause, a magistrate determines if the landlord is entitled to recover damages from the tenant, and if so, how much in money damages. Eviction hearings are held on Monday, Tuesday, Thursday, and Friday mornings in the courtroom that small claims and eviction hearings are heard. Second cause hearings are typically heard after a tenant has vacated the rental property and the landlord has determined that there are damages that need addressed. Magistrates hear second causes Monday through Thursday afternoons. A tenant who feels his or her landlord is not living up to state law in terms of a rental agreement can, after adequate notice of the perceived problems to the landlord, file a rent escrow case in the clerk's office. After a rent escrow case is filed, the tenant pays rent to the court instead of to the landlord until the case is resolved. During a rent escrow case, the amount of rent due may be reduced, and the landlord can ask the court to release some of the rent for repairs. What happens at an eviction hearing? The magistrate will only decide whether or not you should be evicted. This hearing will occur regardless of whether a tenant files an answer or whether a tenant comes to court. If a landlord does not appear for the scheduled hearing, the case will be dismissed unless a continuance has been requested by any party and granted by the court. The date of the hearing will be listed on the summons you received when the case was first filed. Make sure you arrive on time for your hearing at Akron Municipal Court. You will want to make sure you leave time to find parking. Check in with the bailiff when you enter the courtroom. Hearing procedure. The magistrate will hear the case and direct the proceedings. First, the landlord will be given a chance to present his or her side. He or she will try to prove to the court that the lease was properly terminated or the tenant broke the lease, that a 3-day notice to leave was properly served, that no current rent was accepted from the landlord after the 3-day notice was served, and that the tenant is still living in the rental home. Next, the tenant will be given an opportunity to explain his or her side, to explain to the court why you should not be evicted. To prove the case, tenants can show the magistrate a copy of the lease, rent receipts, proof of payment, and explain to the court what really happened. If a tenant does not come to court, his or her side cannot be presented to the court. The hearing proceeds with or without the tenant present if the eviction complaint was properly served to the tenant. Second cause hearings. At the hearing for the second cause of action, bring evidence and witnesses with you to this hearing to prove your claim or counterclaim. Evidence is not accepted by the magistrate outside of the hearing, so it's important to bring whatever witnesses and evidence you have to prove your case to your hearing. Landlords. If you're claiming damage to property, be prepared to testify and provide evidence about the condition of the property when the tenant moved in and the damage to the property you believe was caused by the tenant. Tenants. Be prepared to testify about the condition of the property when you moved in and when you moved out. If things were broken or damaged, but you didn't cause them to be broken or damaged, tell this to the magistrate. Tenants are not responsible for ordinary wear and tear. Bring receipts for all rent and utilities paid if unpaid rent or utilities is part of the claim against you. What to bring with you to court? Physical documents relevant to your counterclaims, such as rent receipts, security deposit receipts, utility receipts, your lease or rental agreement, letters between you and your landlord, inspection notices, code violation notices, and any receipts you may have for supplies you use to make repairs. Bring the originals and copies to leave with the court. Bring photographs relevant to your claims or counterclaims, such as photos of the conditions of your apartment or repairs that need to be made. If photos are on your phone, please print them out. Magistrates will not look at photos or videos stored on a cell phone because the evidence presented in court is retained for court records. Bring copies that you can leave with the court. Bring witnesses who have actually seen the things or actually heard the conversations that you are testifying about at trial. Community resources available to landlords and tenants include Akron Legal Clinic at 330-972-7189. Legal aid can be reached at 330-983-2700. The Akron Bar Association can be reached at 330-253-5007. And Fair Housing is at 330-376-6191.